The new Planning and Development Act is 906 pages long, and we're about to get the highlights from someone who was involved in taking it from a draft bill in 2022 right through to implementing it today.
Well, I think if we look at planning as trying to get the best outcome for society and being focused on the decision or the plan to give a good outcome, I do think that the path to get there has become more complex and more difficult.
Hello and welcome to our first ever episode of the Planners Podcast, brought to you by the Irish Planning Institute. I'm your host, Sean O'Leary. The Planning and Development Act 2024 is the most substantial overhaul of our planning system in decades. Today we're joined by a qualified planner with extensive experience across the private, local and central government sectors, who helped steer the Act from a draft bill way back in 2022 to the legislation being rolled out in 2025 and beyond. Over the next half hour, he'll help to explain the key changes in the planning system, how the Act addresses forward planning and what it means for development management, and the realistic timeline for implementing the new legislation. It's a privilege to welcome the Assistant Secretary heading the Planning Division in the Department of Housing, Local Government and Heritage, Paul Hogan.
Thanks very much, Sean. Thanks for the opportunity today.
Thanks for speaking to us, Paul. And we're going to do a relatively deep, but also relatively concise, I think, dive into the Planning and Development Act 2024 and its rollout. But first of all, I just wanted to talk a bit about you. So you're Assistant Secretary heading up the Planning Division in the Department of Housing, Local Government and Heritage. You're arguably one of, if not the probably most senior professional planner in the public service now. There's some local authority chief executives which are planners, the planning regulator obviously as well, and I'm sure there's others that I'm forgetting. But what do you think of being a trained planner has brought to that kind of senior management role in the public sector like that? Or do you still get to kind of flex your planning muscles? And how have you found that experience of moving from a technical role into a more administrative and management role at that very senior level?
Yeah, it's a very interesting question, and it's one that I ask myself frequently. I think, having thought about it a little bit, the kind of strategic overview that a planner has and the capacity to synthesize lots of different things and make a decision is absolutely key to any kind of leadership role, management role. And I think that it's something that frequently arises in my current job, not just in relation to planning matters, but you can apply it to a range of different considerations.
And we'll come back then to your, I suppose, local authority career and work in Ireland maybe in a bit. But I wanted to get into the legislation itself, I guess, and start with some numbers. So 906 pages, third largest piece of legislation in the history of the state, though I've heard a few versions of what the first two are. So I don't know if there's an internal kind of record in the government departments about what the other two are, but 26 parts. We'll go through it more or less part by part in a moment. 637 sections, 7 schedules, interacts with over 100 other pieces of legislation. And then there's regs as well, and we'll be talking about the regulations too. And there's, I think, another 1,200 or so pages of those. So it's a very kind of big beast. And this might be a bit niche, but I do think it'll be interesting to talk briefly about kind of that sausage making and how the Act came about, how it was drafted, the role of the department, the officials, and things like that. I mean, in my brief and not particularly illustrious career in the civil service, I was involved in drafting secondary legislation, and that was going between us as civil servants, technical advisors, the internal legal team, the AGs, and then wider stakeholders. So yeah, if you could talk a little bit through about who was involved in drafting the Act, how long did it take, and how involved a process was it for the officials who were ultimately responsible for steering it through?
Yeah, well, look, it was obviously a very significant undertaking. And just for the record, I think the other two are the companies legislation and taxes consolidation legislation. Look, the planning legislation, a decision was made in 2021, and it was made at the highest level of government. And I think it's still fair to say that the Planning Act and its implementation is top of the agenda for government. So that level of priority given to, what planning means and how it affects Irish life, was there. And at the time, as I understand it, and again, I'm obviously quite close to it, but I'm not sure who asked who what at what time, but certainly not the current Attorney General, but the previous Attorney General undertook to lead a comprehensive review of the legislation, which was clearly overdue. The Planning and Development Act, as 2000, as it stands now, is almost 3 times as long as it was when originally drafted, and many different provisions have been bolted on, added in. In fact, the number of sections has more than doubled, and some of those sections are incredibly complex and long, and they've been added to fairly complex procedures to begin with. So it was quite clear, from, I suppose, the performance of the planning system, I suppose the growing prevalence of court judgments, court precedent, and court decisions in planning matters, that the Act needed to be updated. It needed to be consolidated and, I suppose, modernized to reflect all that's happened since, and to be able to, I suppose, withstand and address, satisfactorily the level of scrutiny that's being brought to bear through the legal processes, which, again, listen to some, you would believe are affecting the vast majority of decisions. That's not the case. I mean, it's still the case that 88% of planning applications are granted. Only somewhere around 7% end up with an bord pleanála, and only around 0.3% of all decisions end up being judicially reviewed. So really, it is a very small element of the system, but it does tend to, and it has impacted the larger developments, big infrastructure projects, housing developments, renewables projects. They have been, I suppose, a source or an attraction for judicial review for whatever reason, because the impact, more broadly, they're more significant. They affect communities maybe to a greater extent. So in a way, they have become, in fact, I suppose, that the kind of the lightning rod for judicial review, and that has had an impact on the whole system, because it's as I said, it's the precedents, it's the court judgments, it's the fear of litigation that have then fed back into the system in terms of the level of scrutiny, the amount of work that needs to be done to avoid that, and that has had, I suppose, a wider effect than just that 0.03%. And of course, the legislative framework needs to be, is subject to scrutiny as much as the individual decisions, and does need to be. It did need to be overhauled to enable comprehensive review. So the way the review worked was the AG and his team led that, and they started off by looking at each major part and section of the Planning and Development Act 2000 and engaging with my own team in the department. When this process commenced, I wasn't in the role I'm in. I was the principal planning advisor, and did have a role in, particularly in some parts, more directly dealing with the AG's team. And, as the process rolled out, the team within the department engaged with the AG's team. And I think as time went on, there was a increasing engagement and increasing role for the departmental team, that eventually led to the draft Planning and Development Act at the end of 2022. So the process took approximately 15 months to, get that initial draft. And I think it's fair to say the initial draft at the end of 22 was not a complete document. It needed a lot more work to get it to the stage where it could actually be brought through the houses, which took, again, roughly the same amount of time. And by then we had established an advisory group with a range of different stakeholders to feed back into the process. And obviously there was that statutory Oireachtas process to be gone through as well, where lots of different people had initially pre-legislative involvement, and then more formally through the houses themselves, and the Seanad and the Dáil.
And you had a lot of late nights and kind of long committee and debates, discussions and things like that, I think it would be fair to say, as that was making its way through the Oireachtas process. But then something that you did mention there was the priority that the legislation has been given in government. And obviously, the other thing is the changes since 2000. One of the, I suppose, most striking changes since 2000, apart from the complexity of the legislation growing, is that the planning landscape now is quite different. So I guess maybe there's increased emphasis on some aspects of planning coming from Europe. We've got an Office of the Planning Regulator that we didn't have before. We've got a Department of Climate, maybe with kind of an increased role. You've got MARA in the marine space as well. So then you're seeing planning come up, quite prominent in the new program for government and things like that. Was your job, or would your job have been easier if planning was the way it was maybe 25 years ago, where everything was central to the Custom House, there was local authorities, there was the Custom House, and then there was some sort of regional structure? Has that kind of fragmentation made things more difficult, or actually is it a potential positive, or is it something that you're seeing actually have quite good effect?
Well, I think if we look at planning as, trying to get the best outcome for society and being focused on, the decision or the plan to give a good outcome, I do think that the path to get there has become more complex and more difficult. And, one of the things that I've certainly identified is the concept of a kind of a productivity paradox, whereby, the same number of people working in the same system have to have a much wider range of skills and spend more time doing the same thing to get the same level of output. So, ultimately, things take more time and they have to be gone through in more detail. And it's perplexed the political system, but there have been a series of developments and decisions going back to, Ireland signing up to Aarhus in 2012, introducing the kind of the Section 50B special cost rules in relation to judicial review just prior to that, which meant that each side bore its own costs or bears its own costs in a judicial review case. That then being implemented, or interpreted through the Heather Hill judgment as applying to all planning decisions, and I suppose an increasing level of societal concern about decisions manifest in judicial review challenges. So all of those things have led to this situation whereby, it's taking, as I said, more people with more skills, the same amount of time, a lot more time to achieve the same things. And that's, that's frustrating. It's frustrating everybody. So yes, I think the answer is, of course, it would have been a lot more straightforward to, have a kind of a settled Planning and Development Act and regime that was more focused on outcomes. And a lot of planners have said to me over the years, particularly since I've been working in the department, when will things ever settle down? When will they get back to normal? All this constant change is really difficult to handle and it's frustrating us. I mean, I get that. But at the end of the day, planning is about managing change. I know it's managing change in the built environment, and there's enormous pressure on the system, coming externally from Europe, but also domestically to address, the challenges that we face in terms of housing, infrastructure, competitiveness and all that.
And then if we jump into the legislation itself, I guess, so it was signed into law in October 2024. It'll commence over several months. I think the 2000 Act took maybe 12 to 18 months before it was more or less fully commenced. We did see Minister Brown in an interview say that he was expecting it to be implemented over 9 months. So what are you planning for in terms of implementation, or what sort of time frame are you working before people will start to see substantive bits of the legislation start to be enacted and then have the whole thing commenced?
Yes, look, we're working to get the bulk of the legislation implemented by the end of the year. Clearly, there will be things that, may not fall within that, but the intention is to get as much of it as possible done by the end of 2025.
And then if we start going into that kind of more or less part by part and not dismissing maybe part one, which is the preliminary and general bit, I think, as I understand it, some of that has maybe commenced already, just to get the ball rolling. And then part two is about the concept of development. And this might be a good time to talk about the exempted development regs and things like that. I mean, there was some suggestions about log cabins and other maybe kites being floated about what might be exempted and not exempted. Can you talk about that exempted development process, about how those regs are going to be looked at, and maybe when people are going to start seeing some more detail about potential changes to the exempted development regs?
Yeah, so look, we're engaged in a process at the moment with the local authorities, government departments, state agencies to identify what they understand to be elements of the exempted development regulations that may need to be updated or reviewed. This exercise hasn't been undertaken, comprehensively for 25 years at this stage. It was last done when the regulations for the 2000 Act were prepared. So we expect, when we receive the input of other departments and agencies and indeed the local authorities, to put together, I suppose, a proposal that we would then use to consult more broadly and have a general public consultation in respect of this. The aim is to identify things that ultimately aren't significant and don't have an impact to the extent that they need to be assessed by the planning system. And there are lots of things that have changed, I suppose, in the course of the last 25 years, things that simply didn't exist to the same extent at that stage. So, look, I don't want to prejudge it by suggesting what will be in or out, or how it may be dealt with. But it is something that's seen as important to update. And that will, I suppose, be a precursor to inform then how we commence parts of Part 2 and Part 4 in particular of the legislation, because ultimately the development management system is the heart of the planning system, and we need to get it right. I mean, we still have, obviously, in the meantime, we have a development management system, and we're not fundamentally changing it, but there's a lot of streamlining and consolidation proposed as part of the Act, I would say, in this area and this space, probably more so than elsewhere.
And then I suppose one other change that did get some attention, and it's relevant to that concept of development part, is around declarations and who can look for declarations and stuff like that. Can you explain a little bit about why that was done, what the intention was by changing who can seek declarations and things like that?
Yeah, look, the intention behind that was, I suppose, to ensure that the property owner themselves was entitled to due process. In other words, this was, as I understand it, intended to enable a property owner or user to seek a declaration as to what or not may be exempted development, but had instead developed as a means for third parties to engage in some cases, without even the knowledge of the affected person or the property owner. So, on very operating, I suppose, on legal advice and AG's advice on this one, it was proposed to make the changes that we did. There are still provisions that enable ENGOs, for example, to use this provision of the legislation. And in particular, there may be cases to do with things like peat extraction or quarries, for which this would be relevant for an environmental protection perspective. But certainly, the practices that had evolved around this were not seen as robust and were in need of change.
And then we're into Part 3, which is the plans, policies and related matters. There's a couple of things here that I just wanted to talk to you about. I suppose the first was where we are at with the revision to the National Planning Framework. People might be listening to this on their way to the Irish Planning Institute's conference in Galway in April, or on their way back from it. Will people have seen changes to the NPF at that stage? Or when are you expecting those kind of final revisions to be in place, and then the changes consequent to that starting?
Yeah, so look, the National Planning Framework, has been revised. We are about to bring it to government for a final decision. That will require, further to a government decision, it will require sign off by the Oireachtas. So to a certain extent, it's uncertain in that, there's a matter of scheduling and ensuring that we do, engage with the Oireachtas. So I can't be definite about the timeline, but the expectation is that it will happen probably at some stage, by the end of April at the very latest, and that will enable then the revised NPF to be concluded. I guess the process for that.
And a lot of the explanatory notes and things like that around the Act, we're talking about the plan-led system. What does the 2024 Act, when it comes to what is not plan-led about the existing system that the 2024 Act lets us do? If you could just kind of expand that plan-led point, how much more plan-led does it need to become, or what wasn't working that made it less plan-led currently, do you think?
Yeah, well, I suppose there's a number of things. I've talked already a little bit about judicial review and the chilling effect that that's had, and that's very much focused on, decision-making and precedent, and individual precedent, as maybe opposed to a common good set of objectives set out in a plan. So really, it's about kind of ensuring that the planning hierarchy, and I don't like emphasizing that word in the sense that it suggests that it's somehow rigid and inflexible, but certainly there needs to be, a kind of a proportionate or commensurate hierarchy in planning, so that can be, given, it can take effect in a kind of I suppose, an agile and responsive sense. So, look, we have the National Planning Framework, we have regional plans, we have county plans, we've got local plans, all of that. But at the end of the day, if there is a kind of a misalignment, or if your guidance comes in and needs to affect how these things operate, there just isn't the means to ensure that that they can be brought into any sort of meaningful or useful alignment. There's very limited powers on the part of the government or the minister to affect that sort of clarity, and likewise the courts have held that there's only very limited circumstances in which plans need to align. So look, this to a certain extent is about focusing, major strategic national kind of parameters or guardrails on the system, at the right level, nationally, regionally, locally, and then enabling things to happen locally where they should. So even the streamlining of county development plans is about ensuring that those plans can address what they're meant to from a planning perspective. And to a certain extent, county development plans have become a kind of a repository for all sorts of objectives of the local authority, not all to do with spatial planning or even with a physical dimension. So, there is a need to ensure that they're, very, very much focused on the planning function, and that local plans are not being prepared for areas that aren't likely to be subject to significant change simply because of population, and instead reflect priorities. So again, there's the concept of priority area plans. So look, there's an important streamlining here, but there's also important provisions whereby, ministerial guidance is to be in future a national planning statement, and that is to be issued by, with government approval, and that it may include mandatory elements, which are again those sort of, as I said, nationally significant matters that, that are guardrails for the system. So the example I've probably given more than other things is, if there's an objective to increase density in certain parts of towns and cities, that's a national mandatory requirement, and perhaps with parameters such as those set out in the urban development guidelines. But how that's achieved is more discretionary, and there's probably a range of different ways of doing that, and that's up to the individual local authorities. And I think we would wish to see that level of kind of proportionality, a principle of the system. What we have is, as you point out, partly plan led, and certainly in terms of its strict perfect interpretation plan led, but certainly having worked in the department for some time, if a local authority or an element of the system decides that they want to do things very differently, there are very limited powers on the part of the minister or the government to ensure alignment, and it can have a very significant impact then on decision making. And I think another example I would have quoted is a chief executive some years ago telling me, that it's very difficult now to provide advice to, a prospective applicant. And as I said, this is going back some years, but he was saying, the development plan says one thing, the national guidelines say another, and Bord Pranala may do a different thing. And then ultimately, who knows what the courts would decide. So there's all those variables that, perhaps we're working off different sets of priorities at different times and just couldn't be brought into some sort of useful kind of, I suppose, synchronized set of rules for people. And that's just not good enough. I mean, I have to say, if we are to operate a national planning system at different levels, it does need to be capable of interpretation as to what, if you do the right thing, that you will get a reasonable output at the end of it. And I think that's one of the important elements of the system. Of the reforms put forward in the new legislation.
And then speaking about just that council level, how complicated or is it going to be for local authorities who might be having to start a process of reviewing kind of existing plans? There's work being done on LAPs at the moment. There's obviously the guidance, I imagine, will need to be updated as well. So how is all that just going to, I suppose it depends maybe when this is going to commence, but how is that all just going to knit together with local authorities working to the existing legislation and, kind of in some cases maybe quite well along the existing processes? How's that being coordinated, or what does it mean for local authorities who are maybe caught in a kind of in between the two pieces of legislation?
Yeah, look, I think there's always this concept of trying to kind of fix the plane while you're flying the plane. And one of the groups that we've established, with the local government sector in particular, is to address plans and guidelines, or plans in particular. So as a general principle, anything that commences under the current legislation, may conclude under the current legislation. And I think that's something that in our, commencement provisions, we will seek to reflect. As I said, it's still very much, very much part of the commencement process. And that's just work that's ongoing. So, I can't say there will be a perfect outcome, but certainly the principle is not to waste people's work and time, and to ensure that things that are ongoing have some meaning. But look, we'll be communicating that with the sector through this particular group as we go, and it met last week to consider exactly these issues.
And then part 4 is development consents, which we spoke about in the context of, I suppose, the concept of development as well. And then part 5 is developments at Dublin Airport. There's live applications, etc. So there's probably not much that we can say here. But I suppose on a wider point, of all the planning issues in the country, Dublin Airport seems to be one of the most prominent, and maybe some of the decisions or some coverage of it being used almost as a stick to beat planners in some instances. Is there anything changing for Dublin Airport, for example, in this piece of legislation that's important to highlight?
Look, I think, as you said, these are live applications, and just a very general observation. I mean, the noise requirements are another, I suppose, European directive that we are obliged to implement. So there's just a further layering, I think, of environmental regulation that this is arising from. And secondly, this is certainly one of the categories of things that frustrates people in government, and obviously impacts on Ireland's competitiveness. I think it's unfortunate that it has its root in a planning requirement. But look, the reality is it's something that needs to be worked through. And I think it just highlights the importance of the seriousness with which, European environmental regulation needs to be taken by those engaging with the planning system, because it is ultimately, it is the root of a lot of the recent complexity, and it cannot be underestimated. So I think I would, I'd give that message to lots of different developers or people proposing development, or dealing with development, that, it is in some senses, it has been the Achilles heel for judicial review.
And that's where part 6 comes in, which is where all that environmental assessment stuff is living now. And then if we skip down to, I suppose we spoke about judicial reviews, but when is part 9 then, the judicial review and decision making part? When are you expecting that to commence, or what's the timetable that you're working to on the JR changes?
Yeah, so look, part 9 is perhaps another of the really important elements of the legislation. Part 9, chapter 1, we expect to be able to commence fairly imminently as part of the first phase. So I think the kind of procedural provisions will kick in sooner. As a whole, the bulk of part 9 in relation to cost capping and the environmental financial assistance mechanism, we're keeping variable, because these are matters that are, I suppose, if you consider the whole of the totality of the Planning Act is within the control of our department. But there are further government decisions and ministerial consents required in relation to elements of part 9. So we are working very closely with other government departments to bring those to a conclusion. And while we've kind of identified them as a separate block, we feel that they could actually, be brought forward as early as Q2, possibly Q3 this year. But there are matters to be considered, and as I said, there's a degree of uncertainty as a result.
And then part 11 is enforcement, and I suppose we're all familiar with the idea of enforcement being the Cinderella of the planning system, squeezed by the other applications and things like that. When do you think the regional enforcement idea, or did you have some particular uses in mind when it came to the regional enforcement authority idea within the new Act?
Yeah, look, I think, it's fair to say this is something that, again, we're discussing with the implementation group, and it is something that we would like to see perhaps piloted, in a particular region or set of jurisdictions for particular use or purposes. One area that comes to mind, and I'm not saying this is, a definite, but certainly, quarries are quite complex, specialist source of lots of, complaints and enforcement action. But having said that, I mean, that's the kind of a, very clear environmental priority. But having said that, there may well be other areas as well, such as, short-term letting, depending on which way the policy goes on that. So there's nothing definite here, but it does offer that. Like, to be honest with you, the real purpose of this and the real benefit of it is that it enables kind of a centre of excellence and pooling of expertise approach, where you can designate a lead authority, or the minister can designate a lead authority to operate to act on behalf of others, and that is something that perhaps would lead to greater efficiencies.
And then I suppose if we go on to part 12 and we take part 12 and 17 together, which is about appeals and Comisiún Pleanála, what were you trying to achieve with the changes to the board? And I guess the one that maybe got the most prominence is timelines and things like that. So when do you expect those changes to Bord Pleanála to be commenced and people potentially start seeing those mandatory timelines operationalised and things like that?
So look, I think the changes to Bord Pleanála are well flagged, and there were legislative changes at the end of 2022, I think, that set the ball rolling, and for some of this, and it was, I suppose, continued then into the new legislation, the Planning Act as a whole. Look, Bord Pleanála, first of all, has done tremendous work in addressing the backlog of decisions that had built up into 2023. The organisation has accommodated and incorporated, new board members, new inspectors, and new staff generally, and has turned a corner. And it's one of those areas maybe where perhaps people, commenting on the system aren't aware of the level of change that's taken place and what can be done, when intention is brought to bear. So the organisation is now really well set up for the further kind of changes and transformation to become a new organisation, with the same kind of independence and impartiality at its core as the best of it has had, but to enable that independence and impartiality in decision making to be solely in relation to decision making and to focus on that. So that's where the concept of the planning commissioner comes in. What was formerly the board and the former board members, had an element of corporate responsibility and corporate governance oversight, which, again, in a sort of a modern, the context of a modern organization of more than 300 people is incredibly difficult to do, while you're under pressure to deal with a very significant volume of technical decisions. So in reality, that was, a major change that was flagged, I suppose, fairly early on from the various, as necessary from early on, from the various reports that were undertaken by the OPR, by the minister in terms of the action plan. And we're separating out the decision-making on planning cases from, the oversight and governance role. So there will be a non-executive board overseeing the performance of the organisation, setting priorities, working with the new executive management team to really identify, how the organisation can transform into being permanently efficient and responsive, as it needs to be to the needs of the state decision making.
And then there's just three other parts that I was hoping to quickly get your thoughts on. I suppose the one is part 18, which is the Office of the Planning Regulator and the idea of the advisory board. How substantial do you think the changes in terms of the OPR are, or do you consider them to be more iterative maybe as that body gets more established and has been around for quite a while now?
Yeah, look, again, like the board, I mean, the OPR has, again, done an extremely good job over the course of the last 6 years since it's been established. It's had to establish a new set of procedures, and it does a huge amount of work, as well as the core plans evaluation role. It does a lot of work in terms of research and training, education, and indeed assessing the processes and procedures of the different local authorities. So I think it's fair to say that there has been some concern from the political system about the plans evaluation role in particular, and some of it unfair, some of it warranted maybe. But look, in reality, we felt that the most effective thing to do, to provide that sort of assurance to the system was to establish an advisory board, and other agencies such as the EPA have such a thing. Again, done well, the board will be very well placed to assist the OPR in its work and to ensure, again, a degree of prioritization focus. But look, I have to say, it really is intended to be complementary and to make the organisation even better, and to, as I said, to provide that sort of assurance to the political system in particular.
And then just two final parts to take them together would be 21 and 22, which is SDZs and then urban development zones. In South Dublin, you would have, one of the things that I think you'd be most associated with was your role in Adamstown. Have you taken learnings from that? I don't know how often you get back there, but have you taken learnings from the Adamstown process and maybe the other SDZs? Are people going to see a difference between any changes to the SDZs under the legislation and then what were you trying to achieve with the urban development zone concept within the new act?
Yeah, so again, look, there is always, I suppose, the need to reflect and learn on what's gone before. And I think, as a general point, all of what's been done is a kind of a compendium of that based on not just my experience, but the experience of, the team within the department who worked in development management, on development plans, in enforcement. So, there's a wide range of experiences brought to bear to ensure improvement in the system. But like on SDZs in particular, yeah, I could really, again, based on experience, I could see the potential of it. And I think one of the frustrating things is, it is tied to the cyclical nature of development in Ireland, or has been. So I suppose what we were trying to do was to identify, again, there's almost like two levels here. There's the possibility of a kind of an SDZ or UDZ, at a kind of a strategic scale, but then at a kind of a particular scale, when to do with the kind of the individual scheme. So that's one difference, and the other difference is as well as the fact that a lot of the consideration of infrastructure and supporting requirements needs to be done up front, whereas before the designation was a fairly light process, and the consideration of facilities infrastructure was the detailed planning bit that came after. So what we mean by that are a lot of the kind of the work is now done before designation, and that designation can lead to, there's almost like a fork in the road. You can have a designation for an area generally, and the normal planning process still applies, or you can have a designation for an area and all or part of it can be subject to a detailed planning scheme whereby there is no appeal mechanism. So again, it can be tailored to priority, timelines, resources, and also is more agile when it comes to changes. And there's some of the criticism we would have got, I suppose, over the years in relation to SDZs as to how they operated.
And you mentioned the R word there, which I think it is important just to cover before we finish, which is that resourcing piece. And obviously, there's the ministerial action plan and planning resources. There's maybe an opportunity to increase the level of planning fees and maybe move to a more kind of cost recovery type model, maybe, when it comes to actually just getting money in the door. But why do you think we're facing such shortages of planners, and what are you expecting planning authorities in particular to be able to, what will they be able to do more straightforwardly, will they be able to deploy the resources more efficiently under the new act than they are under the current act maybe? And what else do you think needs to be done to try and actually bring up the number of people working in the system and actually maybe streamline processes and bring a bit of innovation to things as well if there is opportunities?
Yeah, look, so we have the Ministerial Action Plan for Resources and Planning, and that was published at the same time as the Planning Bill. And, that's the culmination of work we did with yourselves in the Institute and others, including in particular the local government sector. I think the first thing I'd say is that the issue of planning resources is, and I suppose technical resourcing and filling of posts is an issue internationally. So, if you talk to colleagues in the UK, people as far afield as Australia, Canada, the States, there is a shortage of planning professionals. So it's not unique to Ireland. Certainly, the action plan recognises the need to fill posts, to increase educational opportunities, to look at lifelong learning, upskilling, apprenticeships, bringing people back into the profession, all of those routes, as well as overseas recruitment. But like that, none of these things in isolation are going to make the difference. We also need to look at, as you say, greater efficiencies, things maybe that don't need to be assessed, by the planning system, by planners. So the review of exempted development guidelines is not unconnected in that regard. Also improving processes, procedures are relevant. And as I mentioned already, the work of the OPR in looking at that on a local authority by local authority basis, and very conscious of the fact that, we don't maybe have a unit dedicated to pursuing that or taking that further. One of the things I've done this year, as a kind of reorganization of the division in the department, is to establish a performance and innovation unit that will work with all elements of the planning system to, I suppose, improve efficiency and start to look at, as well as resources and training and all that goes with the greater use of information technology, for example, and obviously AI does have potential, to eliminate some processes to speed things up in some instances.
And two then final questions. I suppose the first is, when is this going to be amended for the first time? Is it the marine protected areas legislation is being prioritised? There was land value sharing legislation as well. Are we already into a cycle where this legislation has to become a living document to a certain extent and will get amended if it lasts 24, 25 years? But what's the first changes that you're expecting that are going to have to be made to the Act as passed?
Yeah, look, I think we're well past that sort of notion of something being settled and fixed. And unfortunately, or fortunately, planning is a very dynamic space. So yes, we fully expect there to be changes. I mean, I can't predict what the first changes will be. And I mean, I could throw into the list you've mentioned there, Water Framework Directive legislation, again, a further European environmental obligation that we need to reflect in the system. So, look, it's inevitable there will be further changes, but we've organised ourselves in the department to ensure that, I suppose, the architecture or the kind of the sequence of the legislation is, first of all, the sequence of the legislation is logical and can accommodate these further changes, at least, certainly for the next few years. But again, how we've organized ourselves in the department as well, where we've, centralized, legislative oversight into one unit that works in a complementary fashion, as I said, to the unit I described, the strategic performance and innovation unit. So, they're two sides of the same coin. There will be, oversight of the legislation and ensuring that, it's almost like in ensuring that it continues to function effectively for the system. And like similarly, the resourcing elements would have to reflect any of these changes as well.
Then finally, I suppose, do you have any closing message for planners who are across sectors, maybe people not involved in those various groups that you mentioned involved in implementation, who are ultimately going to be the ones working with this or implementing this? Is there anything in it that you think will make their jobs easier in the long term that you'd want to call out? Or is there anything else that you just think people need to be aware of as we get into the process of commencing this over the next 12, 18 months or so?
Okay, well, look, I think it is important that there's probably two key things here. One is that concept of planning being a kind of a blocker or kind of a restriction, or this notion of overregulation, particularly in a world where, the emphasis is now on deregulation, on kind of competitiveness, on making ourselves more agile. I was very struck by something that Taoiseach said when he was talking about AI, and he talked about good governance as opposed to regulation. And I do think that, it's something that does transfer well to how the planning system should operate. It is good governance of the built environment to achieve, really good outcomes. And that's a message I would think is important, to get across. I think that in terms of how people operate the system, again, I've seen criticism of, and I've heard criticism of planners as not being leaders, not being decision makers and being afraid to make decisions because maybe the chilling effect of JR, the sheer complexity of different things coming their way and, being reduced to a certain extent to the status of project managers. I do think that leadership element can come through, for planners. And it's a kind of a theme maybe of what I said earlier. At every stage, the planner has to be adding that planning value and bringing this something more, than just a collation of everybody else's reports or views. Ultimately, it's about your kind of convictions and values, as a planner to achieve the best outcome. And, if you can argue, all things considered, this is the right thing to do for the best outcome, I think that's, that sort of core value or core skill set has to stay with the planner. And I think that's where ultimately it's about leadership, particularly when you get to the program level or big decision-making level. And it does really mark out, I think, people who are successful.
Thanks a million for giving us your time and your insights and joining us on the podcast, Paul. And I'm sure we'll talk again soon.
Thanks, Sean. Thanks for the opportunity, and it was my pleasure.
If you would like to find out more about what we covered in this episode, you'll find notes, links, and more in the description area of this podcast. Do remember to press follow for our show so you'll get the next episode automatically, and remember to share it with a friend in the sector. Just tell them to search Irish Planning Institute on their podcast app. Our podcast today was produced by dustpod.io and brought to you by the Irish Planning Institute. From me, Sean O'Leary, thank you for listening.